Good day to all of you. Welcome to the University of San Jose Recoleta School of Law Refresher Course Program. Today, I am tasked to share with you special penal laws. I wanted to remind everyone that the objectives of this presentation is to provide you a quick review of the special penal laws. We will not be tackling the whole of it, but to cover specific provisions only to address time constraints. And of course, you have there to refresh your knowledge on the special penal laws. And I hope this would help you prepare your upcoming bar exams. For purposes of this course, I have prepared 40 special penal laws. For today, our target is to finish these 10 special penal laws as shown on the screen. The next 10 would be on the next meeting, another 10 on the next meeting, and the last 10 on our last meeting. So sit back and relax, and let's start with BP bilang 22, or the bouncing checks law. Basically, you have already an idea what bouncing checks law is all about. It is the law that covers the issuance of a bump check. And what are the elements to successfully prosecute one for violation of BP 22? First, you have there the making, drawing, and issuance of any check to apply for account or for value. Remember that the maker, drawer, or issuer must have knowledge that at the time of issue, he does not have sufficient funds in or credit with the drawing bank for the payment of the check in full upon its presentment and its subsequent dishonor. And who can be made liable for BP 22? The law says any person. And in fact, there are two kinds or two ways within which a person can be made liable under BP 22. First is the person who makes or draws and issues any check to apply on account or for value, knowing that at the time of issue, he does not have sufficient funds in or credit with the drawing bank for the payment of such check in full upon its presentment, which check is subsequently dishonored by the drawing bank for insufficiency of funds or credit, or would have been dishonored for same reason had not the drawer without any valid reason ordered the bank to stop payment. And the second way of making a person liable under BP 22 is having sufficient funds in or credit with the drawing bank at the time he makes, draws, or issues a check. However, he failed to keep sufficient funds or to maintain a credit to cover the full amount of the check if presented within a period of 90 days from the date appearing thereon, for which reason it is dishonored by the drawing bank. So all of this can be found in Section 1 of the law. Now, it is very important that we have to distinguish the two ways within which a person can be made liable under BP 22. Basically, we have to analyze the elements of each act constituting a violation under BP 22. So you have there paragraph 1. The drawing knows of the insufficiency of funds to cover the check at the time of its issuance. Take note that we have to prove knowledge on the part of the drawer at the time of its issuance. Though the law provides for a presumption as contained in the last portion, however, such presumption is disputable. Let's continue. The second element is that the check is unfunded at the time of issuance. So knowledge and that it is unfunded. And the act punishable is the act of issuing a bump check. Now, how do we prove knowledge? While the law provides for presumption, as it states, presentation of the check within 90 days from the date of the check is not an element, but such presentation of the check within 90 days is required to apply the presumption of knowledge of insufficiency of funds, which is an element of the crime. Thus, there is no presumption of knowledge of insufficiency of funds if the check is presented beyond 90 days. Now, why does the law provides for a presumption? Now, take note that knowledge is all in the mind. We cannot see it. Hence, the law provides for a presumption. And that presumption applies only if the drawee of the check presents the same for payment within a period of 90 days. The presumption does not apply anymore if he fails to present the same within the period of 90 days. Now, while this is just a presumption, as I mentioned earlier, it is disputable. It can be further proved by the aggrieved party by notifying the drawer of the check, hence the importance of the notice of dishonor. Now let's proceed first to the second way to which BP 22 can be violated. In paragraph 2 of section 1, at the time of the issue, the drawer or the issuer has sufficient funds. However, what makes him liable under BP 22 is his failure to keep sufficient funds within 90 days from the date appearing on the check. As compared to paragraph 1, the check here under paragraph 2 is funded at the time of issuance. But the act is punishable the moment the issuer or drawer failed to maintain sufficient fund to cover for the check within a period of 90 days from the date appearing on the check. Presentation of the check within 90 days from the date of maturity is an element of the crime. Thus, presentation of the check beyond the period is a defense. Now, by the way, do not forget that the check shall become stale after 6 months from the date of its issue. Hence, the need to present the same within a reasonable length of time. Now, the next question would be, what should we file? Can we file BP 22 against the accused? But some would prefer to file estafa against the accused. Now, the related provision under the RPC is Article 315, Paragraph 2D. That is the issuance of a post-dated check. I have here a table of comparison so that we will be guided as to which or what would be the proper charge to file against the accused. Now, take note that in estafa, deceit and damage are essential elements which are not required in BP 22. In BP 22, the mere issuance of a check that is dishonored gives rise to the presumption of knowledge on the part of the drawer that he issued the same without sufficient funds and hence punishable. However, in Article 315, it is not just the mere issuance. Another distinction is that the purpose of the payment in BP22 is payment for a pre-existing obligation. Now, if the check is issued in payment of a pre-existing obligation, that would negate criminal liability if you file the same under Article 315 of the revised Penal Code. In other words, if the same was issued over a pre-existing, it already existed, and as payment thereof, you issue the check. You cannot file estafa to the accused. You can only file BP22. Now, when can you file both, under both, BP22 and estafa? Now, take note, to make one liable under 3152D for the issuance of a post-dated check, the post-dated check must be issued, and under paragraph 2, the general rule is that you have their false representation, right? Under false pretenses. And a further qualification that the issuance of the check must be the reason why the aggrieved party parted with his money or goods. The fraud there, the deceit there committed by the accused must be done simultaneously or prior or simultaneous to the issuance of the check. There must be simultaneous exchange of the goods or services and the issuance of the check, not pre-existing. With a further qualification that it was the issuance of the check that prompted the aggrieved party to part with his money or goods. That is where we can prove that there was really deceit on the part of the accused at the time of the transaction. So, you can charge him both under Article 315 and BP22 if subsequently the check issued was dishonored. And that filing of both would not actually violate the right of the accused against double jeopardy. Further distinction of the two. In BP22, it is principally a crime against public interest as it does injury to the entire banking system. While in estafa, it is essentially a crime against property under Title 10. In BP22, the violation are mala prohibita, while in estafa, it's considered to be mala in se. As the notice of dishonor, in BP22, it is required that it must be in writing. Oral notification is insufficient. While in estafa, notice of dishonor through a phone call is sufficient. So the jurisprudence substantiating the same is mentioned. Presentment of the check within 90 days is essential in BP22 as this would support the presumption of knowledge on the part of the issuer for the insufficiency of funds at the time of issue. While in estafa, it is not an element. It is not required. Now take note that we sent a notice of dishonor in writing in BP22 and orally, and it can be orally. So meaning to say it can be both oral and in writing. While in RPC, he must make good of the check within 3 days from receipt of the notice of dishonor. While in BP22, within 5 banking days from receipt of the notice of dishonor. Now, what is the significance of this notice of dishonor? Take note that we have their presumption of knowledge. That's why you have there the 90-day period. The presumption of knowledge of insufficiency of funds sets in. However, as I have mentioned earlier, that is disputable. And to disprove that notion that the accused, because he might disprove the 90-day period, he might be able to disprove the 90-day period to make the same conclusive from being a disputable presumption. You have there the notice of dishonor. If within the period of 5 days from receipt of the notice of dishonor, he failed to pay or to make good the check he issued, then that knowledge shall become conclusive. Indeed, he had knowledge of the insufficiency of fund at the time of issue. While in the RPC, estafa, for the issuance of a post-dated check, it's only 3 days. Now, what is the purpose there of the 5-day or the 3-day period? If the issuer, drawer, or maker of the check, after receipt of the dishonor, he'll pay the amount as reflected on the check, then that payment would be a defense on his part because he can disprove knowledge of the insufficiency of fund at the time of issue. So to reiterate, in BP 22, a mere oral notice or demand to pay would appear to be insufficient for conviction under BP 22. It must be in writing, and no disputable presumption of knowledge of insufficiency of funds where there is no receipt of notice of dishonor. Caras versus CA. In other words, actual receipt of the notice of dishonor is very essential. Okay, it is very essential. Why essential? Because that date would make that presumption of knowledge conclusive, of his knowledge of the insufficiency of funds. It is on that date that that presumption or the knowledge of the accused commenced to run. How many days is given to him? 5 days under BP 22. So in other words, what is the effect of no proof of actual receipt of the notice of dishonor? The period of presumption of knowledge does not commence to run. Okay, the period of presumption of knowledge does not commence to run because the period of receipt, it's your reckoning point of the 5-day period within which the maker, drawer, or issuer has to make good of the check. Otherwise, there is that proof of knowledge of insufficiency of funds at the time of issue. Can an endorser be made liable for BP 22? Generally, he cannot be made liable under BP 22 because the law is very clear, maker, drawer, or issuer. So what would be your remedy? Then the list is to prove conspiracy between the endorser and the maker, drawer, or issuer of the check. By conspiracy, you can make him liable as well under BP 22. Now take note of the terms daif and daud. Daif, drawn against insufficient funds, is a condition in which a depositor's balance is inadequate for the bank to pay a check. In daif, the depositor lacks sufficient funds in his account to pay the check. Daif subjects the depositor to liability for such offense. Remember that when the payee of the check receives the check and presented it to the drawee bank for payment, and subsequently the same was dishonored, the drawee bank has to specify the reason of the notice of dishonor. So if the same was dishonored because it is drawn against insufficient fund, then we can make the drawer, maker, or issuer, we can make him liable under BP 22. Okay, we can make him liable under BP 22 unless within 5 days from receipt of the notice of dishonor, he make good of the check or pay for the value of the check. Another reason for the notice of dishonor would be closed account. It is drawn against closed account. Now, how about the other term, daod, drawn against uncollected deposits? It means that the account has on its face sufficient funds, but not yet available to the drawer because the deposit, usually a check, had not yet been cleared. In the case of daod, the depositor has on its face sufficient funds in his account, although it is not available yet at the time the check was drawn. Daod does not expose the drawer to possible prosecution for estafa and violation of BP 22, while daif subjects the depositor to liability for such offense. So I think some of us have experienced depositing a check, and sometimes, especially if you just deposited it, you just deposit it to your account, you did not present it to the drawee bank for payment, it would take time to clear the check. So in your account, it would be, if you check your account later on, it would appear that there is that current balance and available balance. Okay, the available balance is the one that you can withdraw. And if included in your deposit is a check that is still yet to be cleared, the total actually would appear in the current balance. However, you still cannot withdraw it because of the clearing procedure. So if the reason for the dishonor is daod, because your available balance is not sufficient to cover therein, though your current balance is sufficient to cover for the amount, that would not subject the drawer or the issuer for BP 22 or estafa. Okay, again, it is the responsibility of the drawee bank to state the reason for the dishonor. Would it be daif or daod? Okay, please, let's evaluate the following to sum up BP 22. The check was returned and paid with stop payment, although the drawer's deposit was sufficient. Now, take note that it could be possible that there would be dishonor for reason of stop payment. Maybe because the issuer ordered the bank for stop payment because the payee to whom the check was issued did not also perform his obligation, like delivery of goods to the maker or issuer, diba? So if a person issues a check because in payment of the goods he ordered from the payee, so he issues a check for payment. However, the payee failed to deliver. Of course, if I am the issuer of the check, I have to order the bank for stop payment because this person did not deliver the goods I ordered. So why would I pay? Would this subject you for BP 22? No. Okay? Because there is sufficient funds. Actually, there was sufficient funds to cover for the check. The check drawn and issued in the Philippines was dishonored by the drawee bank in a foreign country. Would this be covered under BP 22? The answer is yes. Irrespective irrespective of the kind of check. But our laws would still apply because it was drawn and issued here in the Philippines. Even if the same was dishonored by the drawee bank in a foreign country, the issuer, the drawer, can still be made liable because of the dishonor, the subsequent dishonor of the check, for whatever reason. Not whatever reason. It must be for insufficiency of funds or close account. The check was presented to the bank for payment 6 months after the date of issue. Would this subject, of course, after 6 months, that check would not be honored anymore. Why? Because it is already stale. So your failure to present it within the reasonable length of time would not help you pursue the drawer or issuer of the check for BP 22. The drawer of the dishonored check paid its value within 5 days from notice of dishonor. So we've mentioned this already. So this is a defense. The actual payment during that period, within that 5-day period within which you are given the opportunity to make good the check you issue. So of the 4 instances, it's only on the second scenario that a person can be made liable under BP 22. So that ends BP 22. Let's proceed with anti-fencing law under PD 1612. Of course, you are already familiar with this. So you have there the term fencing and the fence. Fencing, it's not only the buying or receiving, but it also includes possessing, keeping, acquiring, concealing, selling, or disposing, or shall buy and sell. Take note that that article, item, object, or anything of value which he knows or should be known to him to have been derived from the proceeds of the crime of robbery or theft. Okay, you have knowledge or should have known to you that the same is derived from the proceeds of the crime of robbery or theft. That is where PD 1612 comes in. So under PD 1612, what are the elements to make one liable under PD 1612? That a crime of robbery or theft has been committed, that the accused under under PD 1612, he took no part in the robbery or theft, but he buys, receives, possesses, keeps, acquires, conceals, sells, or disposes, or buys and sells the object subject of the thievery or robbery. The accused knows or should have known that the thing was derived from that crime, that by the deal he makes or intends to gain for himself or for another. So in other words, usual that we can, as a caveat to us, if something would be dealt to us, is that on the price, of course, the disparity of the price, if the seller is the identity of the seller, or let's say that he cannot present any receipt for that matter, or let's say just like the cell phone, how could he just sell the phone without the charger? So those circumstances would actually give you a caveat already not to buy it, because it is your responsibility. You should have known that the same could be a subject from a robbery or theft. Now take note that in Section 5, there is that presumption of fencing. And what is that presumption includes? Mere possession, okay? Mere possession of any goods, article, item, object, or anything of value which has been the subject of robbery or thievery shall be prima facie evidence of fencing. Its violation is regarding as malum prohibitum, hence no proof of criminal intent is required. When is a clearance permit to sell used second-hand articles indispensable? Now, in Section 6, if said clearance is required if several conditions are met. First, that the person, store, establishment, or entity is in the business of buying and selling of any goods. So meaning to say he is engaged in the buy and sell of second-hand goods. Second, that such thing of value was obtained from an unlicensed dealer or supplier thereof. Meaning to say, he did not bought it from a licensed dealer. Meaning to say, he did not buy it from a person engaged in business as well, or a supplier for that matter. And third, that such thing of value is to be offered for sale to the public. So if you notice on those, like the pawn shops that we have, many there would pawn their goods or anything of value. And if they fail to redeem it, oh, of course, it would be remate, di ba? By the store. So if that store would offer it for sale to the public prior to the actual selling, they have to obtain a clearance or permit from the chief of police to do it. That is where the clearance or permit to sell shall be necessary. Now, what's the purpose? In order to verify whether or not this particular item was reported being a subject of thievery or robbery. Now, can we actually make this cobrador de malape liable? Now, usually, if you are a victim of shoplifting, these police officers actually knows where to go because of the profiling that they already have, especially in a particular area. If you will tell them in this street I was robbed, or there was thievery took place, they know where to go. Now, if you are just vigilant on your rights, save those sa nagtinarong, they can actually help you retrieve your object or your thing or anything of value. And this cobrador, these stores would actually just give, if you can actually able to prove as well that indeed this item is lawfully belongs to you, because they knows those are the risks in their business actually. And besides, if you have experience, if you go to these pawn shops and you want to pawn something, actually they also had that procedure and verifying your identity to be the true owner of this particular item that is being pawned. So those are actually the measures that are actually they are doing. So sometimes, or there are actually stores for that matter that really become the recipient of this item subject from snatching. So if you would go after them, they would just actually give it for fear of being made liable under PD 1612. Remember, known or should have known. Now, is conviction of the principal, the actual perpetrator of robbery or thievery, necessary before one can be prosecuted under PD 1612? So in Lim versus People, conviction of the principal in the crime of theft is not necessary for an accused to be found guilty of the crime of fencing. Okay? For as long as the aggrieved party can prove that I was robbed, I was snatched, so the person in possession can be prosecuted under PD 1612, even not prosecuting the actual robber or the snatcher. Okay, so that ends PD 1612. Obstruction of justice. What constitutes obstruction of justice? You have there the penalty, and any person who knowingly or willfully obstructs, impedes, frustrates, or delays the apprehension of suspects and the investigation and prosecution of criminal cases by committing any of the following acts can be made liable under PD 1829. So if you notice, I highlighted knowingly or willfully, and you have there the specific acts of the accused there. And take note, this would apply only in criminal cases, investigation and prosecution of criminal cases. It would not apply to any other case. So what are the sample acts or the most specific act that constitutes obstruction of justice? Usually, these are acts of an accessory, just like in fencing. You profit from the effects of the acts of the principal. So in obstruction of justice, you have there preventing a witness from testifying. You also have there altering, destroying, or suppressing the paper record or document that would impair its veracity, authenticity, legibility, availability, or admissibility as evidence. Many of these during bypass operation, some of the relatives or family members of the accused would obstruct the procedure. Some would block the way of the police officers when trying to arrest, or let's say would conceal or destroy even during the inventory. Those are acts of obstruction of justice. You also have their harboring, concealing, or facilitating the escape of any person, publicly using a fictitious name for the purpose of concealing a crime, delaying the prosecution of the of criminal cases, and so on and so forth. Just go over them. Okay, even of giving false or fabricated information to mislead or prevent the law enforcement agencies from apprehending the offender. Now, take note that in PD 1829, just like PD 1612, they are malum prohibitum. And to reiterate, in 1829, it applies only on a criminal case. Now, by the way, I've mentioned earlier that PD 1612, PD 1829 relate this to the acts of an accessory under the revised penal code. Now, take note that you have there Article 20, which provides for exemption from criminal liability to some of the accessory as enumerated under Article 19. Now, Article 20 does not apply only if the act of the accessory falls under the first paragraph of Article 19, that is, profiting from the process of the crime. The exemption does not apply to the accessory. Yes, he is an accessory because his acts falls under any of the acts mentioned in Article 19 of the RPC, but because of his relationship as provided under Article 20, the accessory may be exempted from criminal liability if his act falls under paragraph B and paragraph C of Article 19. Okay? He is an accessory, but no criminal liability if his act falls under paragraph B and paragraph C of Article 19. Question: can that exemption under Article 20 of the RPC applies to a person charged under PD 1612 or PD 1829? Let us say that he is a relative, mother or father or son of the principal accused. Can that exemption under Article 20 applies if you are charged under PD 1612 or PD 1829? The answer is no. Because in PD 1612, PD 1829, you are not charged as an accessory, but you are charged as a principal. Hence, the exemption of the accessories under Article 20 does not apply. Okay, so that ends PD 1829. Let's proceed with anti-wiretapping. Okay, anti-wiretapping is as well a very old law, but it is still in effect. What are the punishable acts punished under RA 4200? To tap any wire or cable, or by using any other device or arrangement to secretly overhear, intercept, or record such communication or spoken word by using a device commonly known as a dictaphone, dictagraph, or dictaphone, or walkie-talkie, or tape recorder, or however otherwise described, not being authorized by all the parties to any private communication or spoken words. Take note, there must be tapping of any wire or cable. Purpose to secretly overhear or intercept. And take note, not being authorized by all the parties, because it could be possible that one of the parties commission you to secretly overhear his communication with the other one. So all the parties, consent of all the parties are required to record or to any private communication or spoken word. Another act punished under 4200 is the unlawful act of a person, whether he is a participant or not in the conversation, to knowingly possess any tape record, wire record, desk record, or any other such record or copies thereof of any communication or spoken word secured either before or after the effective date of this act in the manner prohibited by this law, or to replay the same for any other person or persons, meaning to say that would still constitute a violation under 4200. Another act, to communicate the contents thereof, either verbally or in writing, or to furnish transcriptions thereof, whether complete or partial, to any other person. So in other words, it is not just the tapping of any wire to record secretly any conversation, because there are actually many acts constituting a violation under RA 4200. It shall likewise be unlawful to aid, permit, or cause to be done any of the acts declared to be unlawful in the preceding section, or who violates the provisions of the following section, or of any order issued thereunder, or aids, permits, or cause such violations. So basically, this is an act of an accessory under the RPC. Simply put, secretly overhearing, intercepting, or recording private communication by means of the devices enumerated therein, knowingly possessing any tape record, wire record, desk record, replaying the same for any other person, communicating the contents verbally or in writing, and furnishing transcription thereof, complete or partial. So those are the acts constituting a violation under RA 4200. Exception. So there is an exception. What is the exception? Provided that the use of such record or any copies thereof as evidence in any civil, criminal investigation or trial of offenses mentioned in Section 3 thereof shall not be covered by this prohibition. In other words, the evidence should be an exception because if any evidence obtained in violation under Article RA 4200 General Rule, inadmissible in evidence. By way of exception, As to the inadmissibility of the evidence, it shall be admissible in evidence against those who violates RA 4200. And to cite as a particular illustration, example, you have their judges and prosecutors. Of course, during trial, the judge may require the playing of the recording obtained in violation under Article 4200. The prosecutor may use transcription or playing or possessing this recording obtained in violation of Republic Act 4200. So their act of possessing, using, or replaying shall not constitute a violation under Article 4200 by way of exception to the rule. Okay, while this may be inadmissible as far as the accused whose conversation was unlawfully recorded, but the same shall be admissible in evidence to those persons charged under Republic Act 4200. Okay, it can be used as evidence against those who are prosecuted under the Act. Exception to the exception is as far as a peace officer who records secretly, who intercept your private communication. When shall that exception to the exception applies? If the act of the peace officer in tapping a wire, in tapping a cable to secretly overhear or intercept your spoken word or communication with another person is authorized by a written order of the court to execute any of the acts declared to be unlawful under RA 4200 in cases involving the crimes of treason, espionage, provoking war and disloyalty in case of war, privacy, mutiny in the high seas, rebellion, and such other crimes provided under the law. Okay, those acts alleged to be committed by persons against our national security. It even includes kidnapping. Okay. Now, would there be an issue with respect to the definition for private communication from private conversation? Because the law says private, was it private communication, private conversation? Let's go back for a while. Private communication. So the law speaks of private communication. But the accused may argue that he is engaged in private conversation. Is there a difference between the two? So in the case of Ramirez versus CA, the word communicate comes from the Latin word communicare, meaning to share or to impart. In its ordinary signification, communication connotes the act of sharing or imparting as in a conversation or signifies the process by which meaning or thoughts are shared between individuals through a common system of symbols. This definition are broad enough to include verbal or non-verbal, written or expressive communications of meanings or thoughts, which are likely to include the emotionally charged exchange. In other words, they are used interchangeably. So private communication includes private conversation. Take note that the accused to be liable under 4200, there must be a device or arrangement. Not exclusive as to what has been enumerated, because it mentions dictaphone, dictagraph, tape recorder, walkie-talkie. So they are not exclusive as to what has been enumerated, but may include instruments of the same nature, that is, instruments use of which would tantamount to tapping the main line of a telephone, instruments whose installation or presence cannot be presumed by the party or parties being overheard. Take note, tapping the main line. So in other words, an extension telephone cannot be placed in the same category as a dictaphone, dictagraph, or other devices enumerated in Section 1. So if your party line in your phone, because his phone rings, so he pick it up only to know that it was his party line who had a conversation with someone else, and he overhears their conversation. Can you charge your party line under 4200? No. He did not tap any wire. He did not put any device there to overhear. So telephone extension or an extension of your telephone cannot be placed in the same category. The law refers to a tap of a wire or cable or the use of device or arrangement for the purpose of secretly overhearing, intercepting, or recording the communication. So that ends anti-wiretapping. Illegal gambling. Unfortunately, PD 1602, despite the same is too old, it is still a good law, despite the fact that we have RA 9287. So what is illegal gambling, or what is gambling in the first place? Gambling is any game or scheme, whether upon chance or skill, wherein wagers consisting of money, articles of value, or representative of value are at stake or made. And who can be made liable? And when can he be made liable under PD 1602? Take note, any person. Any person, boy, girl, gay, lesbian, for as long as you are a person. Other than those referred in the succeeding subsection, who in any manner shall directly or indirectly take part in any illegal or unauthorized activities or games of. If you notice, there is a very long enumeration of activities or games. But the law says illegal or unauthorized. So since we have there a very long enumeration, let's just go back to what we presume is legal. Activities or games governed by the PAGCOR, governed by the PCSO. You also have the Philippine Amusement and Gaming Corporation. You have there the Games and Amusement Board. And all those activities to which a permit was given by the LGU, especially during fiestas, or there is that activity of the balikbayan, so there is that merrymaking. Executive order was issued for that purpose. A permit was issued. So other than that, outside those enumerated, they are considered to be illegal or unauthorized activities or games. That's why if you notice here, there are so many enumeration and even includes its derivatives and variants or derivatives for that matter. You have there your cockfighting, wetting, high alay, horse racing, and you have there blackjack, 7-Eleven, what else? Mahjong, no? Car racing, boat racing, drug racing, dog racing, basketball, boxing, volleyball. To include game fixing, point shaving, and other machination, banking or percentage, or any other game scheme, whether upon chance or skill, wherein wagers consisting of money, articles of value, or representative of value are at stake or made. Gambling. Illegal gambling. And you can be charged under PD 1602. What is common in the community right now is biking. Would that be included? Can you be charged for PD 1602 if you will be caught biking and actually where you are actually how would I say it? You are actually betting on who will be the winner on your biking competition. And in fact, even if you are just biking on an ordinary or normal day, some of them are actually betting on who will be the winner. Would that be 1602? For me, it's yes. It's a yes. Because the law says whether it is upon chance or skill, wherein wagers consisting of money or articles of value or representative of value are at stake or made. Your only excuse so that you will not be made liable under PD 1602 are those authorized, let's say, by the local chief executives. Because I don't think so that it is under PAGCOR or PCSO or the Games and Amusement Board in your ordinary biking session with your friends. Okay? So please be careful. Who else can be made liable? Any person who shall knowingly permit any form of gambling referred to in the preceding subparagraph to be carried on in an inhabited or uninhabited place or in any building, vessel, or other means of transportation owned or controlled by him. Now take note that some of this for easy escape, it might be done in a vessel or other means of transportation. Would that be part or covered under the law? Yes. Because illegal gambling is illegal gambling no matter where you perform it. Upon the maintainer or conductor of the above gambling schemes and also the maintainer, conductor, or banker of said gambling scheme, if he is a government official or where the government official is the player, promoter, referee, umpire, judge, or coach in case of game fixing, shaving, and machination, he can also be made liable under PD 1602. Who else? Any person who shall knowingly and without any lawful purpose in any hour of the day possess any lottery list, paper, or matter containing letters, figures, signs, or symbols pertaining to or any manner used in the games of betting. So that is possession. It's actually a prima facie evidence. Upon any barangay official who, with knowledge of the existence of a gambling house or place in his jurisdiction, fails to abate the same or take action in connection therewith. So sort of the dereliction of duty on the part of the barangay official who failed to prevent gambling in his locality. A security officer, security guard, watchman, private or house detective of hotels, villages or buildings, enclosures, and the like could also be made liable under PD 1602. Now, is wager really an element of the crime? Because the law says wherein wagers or money is at stake or any representative of value. In a case, US versus Rafael, it was held that the playing of monte for money is not a necessary element. It seems that when the law names the games punishing any person who take part therein, its purpose is to prohibit absolutely those games. And in the case of US versus Palma, because this would negate direct or indirect participation in the game, a mere bystander or spectator in a gambling game is not criminally liable because he does not take part directly or indirectly. The law does not make the mere presence in a gambling house an offense. But if you notice, these are old cases. If you apply it nowadays, it is really very hard to understand or to believe. If you are there, let's say in the cockfighting arena, if you are just there as a bystander or spectator. So whatever it is, if there would be raid that will be done, of course, you are putting yourself at risk of being included to those who will be arrested. Of course, that would be your defense, that you are just a mere spectator, that you went there to pray. Okay, so that is your on lookout. But those are the acts of illegal gambling. Now, I've mentioned 9287. Did RA 9287 amend 1602? I mentioned earlier, 1602 is still a good law. So what was the amendment under RA 9287? It just amends the penalty of those gambling involving numbers. So we have their illegal numbers game by increasing its penalty. So what are these illegal number games included in RA 9287? So illegal numbers game, any form of illegal gambling activity which uses numbers or combinations thereof as factors in giving out jackpots such as wetting, masyaw, last two, masyaw, last two, you have their suertres. So it is actually covered under 9287. What else? Because you have their variance. Okay, variance. It is included. And then I define a bettor, the staff. You also have there the collector, coordinator, maintainer. Why I included them? Because in the law, in 9287, the penalty given to the infractors, violators of the law would depend upon your participation in the illegal gambling activity. Okay, so if you are a bettor, your penalty would just be, let's say 90 days. That's 3 months. The more that your hierarchy in the illegal gambling activity is higher, then the higher the penalty that shall be imposed upon you. So what are the punishable acts under RA 9287? Any person who participates in any gambling game shall suffer the following. So I've mentioned this earlier, 30 days to 90 days for a bettor. Becomes 6 years to 8 years if you are a personnel or staff. And then it becomes higher and higher as you climb up the ladder to your participation in the hierarchy of the activities considered to be illegal number games. Okay, so you have there the collector or agent, supervisor, manager, operator, capitalist, protector, or cuddler. Would even reach to 16 years and 1 day to 20 years. So if you notice, in the punishable acts, the list is the better. Okay, within the jurisdiction of the first level, because the next one 6 years and to 8 years already, RTC. So what happened here, they don't actually charge you under better, but personal or staff, especially if during your arrest you are in possession of these other gambling paraphernalias, which is considered to be a prima facie evidence against you, the possession of these articles. So ending in the RTC, you enter into a plea bargaining under the first paragraph. So the presumption I am mentioning is stated in Section 4. Possession of any gambling paraphernalia and other materials used in the illegal numbers game operation shall be prima facie evidence of any offense covered by this act. Can a public official be made criminally liable under the law? The answer is yes. Okay, the answer is yes. In fact, aside from the penalty to be imposed upon him, if he is a public official, you have their perpetual absolute disqualification from public office. Okay, perpetual disqualification from public office, even to those public officials who failed to abate or take action or tolerates the illegal gambling activity within his jurisdiction. Parents and guardians are even liable if their children, their minor or ward was caught violating under the law. So they will also be penalized to the point that they will be deprived of their authority over the minor. So the law is so harsh, but it is the law. There is also such thing as recidivism in 9287, and the higher penalty, the next higher in degree, shall be imposed upon you the second time that you are caught violating the law. Okay, so that ends RA 9287. RA 7610. Who is a child or who are considered to be children? Of course, you have there below 18 or over. It includes over 18 but unable to fully take care of themselves or protect themselves from abuse, neglect, cruelty, exploitation, or discrimination because of a physical or mental disability or condition. So those are considered to be children. Now, in a case, the victim is a 21-year-old polio victim. She was not able to study. She could only write and read her name. Is she a child covered under this law? Unfortunately, in this particular case, the court ruled that she is not considered as child within the contemplation of the law, as no evidence was presented to show that he was incapable of fully taking care of himself. There are so many there that there are one hand or no hand at all, but then they can still protect themselves. So in this particular case, there was no evidence presented that the 21-year-old with his physical disability cannot take care of himself. So unfortunately, in this case, she was not considered to be a child. So if he is not a child, then probably you can just file a case against the accused under the other provisions of the revised penal code, but not under RA 7610. What is child abuse? Okay, what is child abuse? It refers to the maltreatment, whether habitual or not, of the child, which includes any of the following: psychological and physical abuse, neglect, cruelty, sexual abuse, and emotional maltreatment, any act by deeds or words which debases, degrades, or demeans the intrinsic worth and dignity of a child as a human being, unreasonable deprivation of his basic needs for survival, failure to immediately give medical treatment to an injured child, resulting in serious impairment of his growth and development or in his permanent incapacity or death. So those are the acts of child abuse. We also have other acts constituting child abuse under Section 10. Circumstances which gravely threaten or endanger the survival and normal development of the child, which includes, not Section 10. Being in a community where there is armed conflict, working under conditions hazardous to life safety or normal development of the child, living in, fending for themselves in the streets, being a member of an indigenous cultural community, living under conditions of extreme poverty, being a victim of a man-made natural disaster, circumstances analogous to those stated, those are still considered to be child abuse. Most common act punish, you have there section 5. Children, whether male or female, who for money, profit, or any other consideration, or due to the coercion or influence of any adult, syndicate, or group, indulge in sexual intercourse or lascivious conduct, are deemed to be children exploited in prostitution and other sexual abuse. So that is section 5. Who can be a victim? Any child, whether male or female, who for profit or money or other consideration due to the coercion or influence of an adult, it could be a syndicate, he indulged in sexual intercourse or lascivious conduct. He is deemed to be exploited in prostitution. If it is for money, if it's for any other consideration, he is deemed to be a child subjected to other sexual abuse. Then you have there the penalty. But who can be made liable under section 5? First is acting as a procurer of a child prostitute. It's the act of the pimp. Okay, it is the act of the pimp. A person who induce another person to be a client of a child prostitute by means of written or oral advertisements or other several means, taking advantage of influence or relationship to procure a child as prostitute, threatening or using violence towards a child to engage him as a prostitute, or giving monetary consideration, goods, or other pecuniary benefit to a child with intent to engage such child in prostitution. So in other words, the act of the pimp, the act of a person who prostitutes the child. Did he actually indulge in sexual intercourse or lascivious conduct to the child? He did not. He just procured, he just secured, he just offered the child to another person. He prostituted the child. So that is the act of the pimp, punished under 5A. Okay, 5A. Those who engage in or promote, facilitate, or indulge child prostitution. So that is 5A. Who else would be liable? This is an element to when a person can be made liable under 5A. The accused engages in, promotes, facilitates, or induces child prostitution. The act is done through but not limited to the following. So these are enumerated in section 5. And then giving monetary consideration, goods, or other pecuniary benefit. The child is exploited or intended to be exploited in prostitution. The child is below 18 years of age. So if you notice here, it did not mention about consent of the child. In other words, consent of the child is immaterial. Even if the child accede, the child agree, the pimp is still liable under section 5A. So who else is liable under section 5? The person who had actual sexual intercourse or committed other acts of sexual abuse on the child is liable under section 5B. Okay, section 5B. The person who had actual sexual intercourse or committed acts of sexual abuse or lascivious conduct to the child, punished under section 5B. Now, take note that if the victim is under 12, the perpetrator shall be prosecuted under 335 for rape and 336 for acts of lasciviousness. But take note of, was that RA 11.6? I forgot for a while. 11.648, okay? 11.648 that future prosecution might be affected by this law because 11.648 amends rape that instead of the under 12, you have their under 16 years of age, the age of consent. Okay, so what is important is that the person who actually indulge in sexual intercourse or lascivious conduct with the child shall be prosecuted under 5B. Elements. Accused commits the act of sexual intercourse or lascivious conduct, is performed with a child exploited in prostitution or subjected to other sexual abuse. The child, whether male or female, is below 18 years of age. Who else? You have there the establishments. Those who derive profit or advantage therefrom, whether as manager, owner of the establishment where the prostitution takes place, or of the sauna, disco, bar, resort, place of entertainment, or establishment serving as a cover, or which engages in prostitution in addition to the activity for which the license has been issued to said establishment. So the owners of these places where the prostitution or to where a child was subjected to other sexual abuse took place shall be prosecuted under Section 5C. What is lascivious conduct? Because sexual intercourse is very clear. That is the insertion of the male organ to the genital of the opposite sex. But what is lascivious conduct? The intentional touching either directly or through clothing. Okay, even if the child is wearing a clothing of the genitalia, anus, groin, breast, inner thigh, or buttocks, or the introduction of any object into the genitalia, anus, or mouth or of any person, whether the same or opposite sex, with the intent to abuse, humiliate, harass, degrade, or arouse, or gratify the sexual desire of any person, bestiality, masturbation, lascivious exhibition of the genitals or public area of a person, that is considered to be lascivious conduct covered under this rule. Okay, so what is the difference between rape under Article 266A and Section 5 of 7610? So in rape, under the revised Penal Code, Paragraph 1, the offender is a man. In Section 5, the offender is also a man. In RPC, rape, carnal knowledge, it involves carnal knowledge of the woman. We are referring to 266A, the traditional rape. While in 5.1, first paragraph, he indulges in sexual intercourse with a female child exploited in prostitution or other sexual abuse who is 12 years old or below 18 or above 18 under special circumstances, because these are still considered to be a child. In 7610, it involves coercion or influence of any adult, syndicate, or group employed against the child to become a prostitute, whereas that is not present in 266, Article 266. So to reiterate, you have the Republic Act 11.648, which basically amends the fourth circumstance attending the commission of rape from under 12 to under 16 years of age. Now you have there the case of People versus Tulagan, GR number 227363, which gives us a proper designation to what crime shall be charged against a particular accused. Now, if the act of the accused involves acts of lasciviousness committed against children exploited in prostitution or other sexual abuse, he shall be prosecuted under the revised Penal Code 336 if the child is under 12 or is demented, because that is the provision under Section 5 under 7610, that he shall be prosecuted under the revised Penal Code. So what would be the proper designation? Acts of lasciviousness under Article 336 of the RPC in relation to Section 5B of RA 7610. That would be the proper designation. Why it is in relation? Because the law says that the penalty in Section 5B of RA 7610 shall be imposed upon him, which is higher as the penalty provided under the RPC. Now, if the child is 12 or below 18, because this one is under 12 or is demented. If 12 or below 18 or 18 under special circumstance, the designation shall be 5B of 7610. Okay, 5B of 7610. Now, take note that this case of Tulagan was decided by the Supreme Court prior to the passage of RA 11648. So basically, we have to apply it by implication. This one would be under 16. This one is if 16 or below 18 or 18 under special circumstance. So we just have to adapt it. So that's how you do it. Now, next scenario. Sexual assault committed against children exploited in prostitution or other sexual abuse. What would be the charge against the accused? It would be Article 266A, paragraph 2 of the RPC in relation to Section 5B of RA 7610 if the child is under 12 or demented. If 12 or under 18 or 18 under special circumstance, it shall be 5B of 7610. How about sexual intercourse committed against children exploited in prostitution and other sexual abuse? So it would be rape, except when the victim is 7, to which the penalty of death shall be imposed upon him. But if 12 years old or below 18 or 18, so this one is if below 12. So if 12 or below 18 or 18 under special circumstance, 5B of 7610 shall be the designation of the felony or the charge. Rape by carnal knowledge. It would be rape if the victim is below 7, as the death penalty shall be imposed upon him. Rape under 266A, paragraph 1, if 12 years old or below 18 or 18 under special circumstance. And how about if 18 years old or over? Rape, plain and simple, because she is no longer a child. Rape by sexual assault. Sexual assault under 266A, paragraph 2, if below 12 or demented. But if the victim is 12 or below 18 or 18 under special circumstance, 5B of 7610. If 18 or over, sexual assault under 266A, paragraph 2 of the RPC. Again, because this one, the victim is no longer a minor. Now, in Section 10, now if you notice, in Section 5, it deals with sexual intercourse, acts of lasciviousness to a child subjected to prostitution and other sexual abuse. So how about other acts of abuse? It is covered under Section 10. Section 10 of 7610. So any person who shall commit any other acts of child abuse, cruelty, or exploitation. So usually by these other acts of abuse, we are referring to physical abuse, psychological abuse. Because again, in the sexual abuse, it is covered under Section 5 of the law. And then you also have there any person who shall keep or have in his company a minor of 12 years or under, a minor of 12 or under 10 or more his junior in a public place, you are also liable under Section 10 of 7610. And any person who shall induce, deliver, or offer a minor to anyone prohibited by this act. And then it may even include a qualifying circumstance. If the perpetrator is an ascendant, the parent, guardian of the minor, the penalty is higher and loss of parental authority. And then owner or manager entrusted with the operation of any public place or private place of accommodation to where the child was brought by the adult. So it is covered under 10D. And any person who shall use, coerce, or use or intimidate a street child to do the following: begging, act as a conduit or middleman in drug trafficking or pushing, or conduct any illegal activities, he is covered under Section 10E. 10E. And in fact, for his prosecution of the other acts to which he uses the child as a middleman, the use of the child shall also be considered as an aggravating to that particular offense or crime he commits, and different charge under 7610. So again, what could be the other abuse that the law punishes? You have their physical abuse. And it accompanies emotional and psychological abuse. Now, a question is being raised. What would be the charge against the accused if he inflicts injury upon the child? Would it be 7610 for physical abuse, let's say, or emotional or psychological abuse, or would it be under the revised penal code? Especially if the injury sustained by the child is slight physical injury, for example. So I have here a definition on what constitutes physical abuse. You have you can see this in the implementing rules and regulation of 7610. Physical injury therein to constitute physical abuse includes but is not limited to laceration, fractured bones, burns, internal injury, severe injury, or serious bodily harm suffered by a child. However, so if you notice, laceration, fractured bones. However, what if it is only hematoma, contusion? It does not partake the nature of the injury described in the implementing rules. My stand, if it is just hematoma, contusion, the accused can be charged only for slight physical injury under the RPC. That could never be physical abuse contemplated in RA 7610. Okay, that is clear. However, there are many parents who are really very insistent, even if the injury of the child suffered is just a contusion or hematoma, what would be your remedy to make it child abuse? Go for the psychological injury. So, you have to subject your child to a psychological evaluation that even if the physical injury of the child was just contusion or hematoma, but then that contusion or hematoma expose the child to being psychologically abused or through emotional abuse, then that would mean that you can file or you can charge a complaint for RA 7610 against the accused, despite the fact that the injury sustained by the child is only contusion or hematoma. Okay, so meaning to say, we converted it to 7610. You have to accompany your contusion and hematoma physical injury with a psychological evaluation report that indeed your child suffered emotional abuse, psychological abuse because of the incident, because of the injury sustained by the victim from the accused. Okay, so that is how you substantiate your claim under 7610. So from the slight physical injury, unta lang sa RPC, but because you were able to substantiate it with a psychological evaluation showing that indeed your child suffered emotional abuse because of the incident, then you can charge the accused under RA 7610. So what can we learn from this? It's not automatic that because the victim is a child, automatically 7610. No, you have to substantiate your claim so that your efforts would not be wasted. Okay. Name calling, would that be child abuse? Yes, that would be. You have to submit a psychological evaluation report substantiating your claim that your child suffered emotional abuse. Bullying, that would also be a form of psychological and emotional abuse. Now, I want to show you Republic Act 10627, the Anti-Bullying Act of 2013. Now, this law is applicable only if the bullying happens on school grounds, property immediately adjacent to the school grounds, meaning to say, it is related, something to do with the schooling of the child. That is under paragraph 1. In paragraph 2, while it is done outside the school ground or premises, but it was on the occasion of activity, function, or program that might not be school related, but it uses the technology or electronic device owned, leased, or used by the school. And it creates a hostile environment at school for the victim, infringe on the rights of the victim at school, or materially and substantially disrupt the education process or the orderly operation of a school. It shall be covered under 10627. And another thing, if there would be retaliation, the bullying was through a form of retaliation against a person who reports bullying, who provides information during an investigation of bullying, or who is a witness to or has reliable information about bullying. So we have to relate it to the first two paragraphs. That is covered under 10627. Other than that, you can charge the accused under 7610. You also have this, a form of child abuse. Okay, basically this would show to us that this child is subjected to other sexual abuse. And this one, other forms of neglect. So who can be made liable of this? It could be the parents. Okay, parents or other adults. No question. I have encountered that a complaint for child abuse was filed because the child was actually caught on fire. He was on crossfire when these two adults are actually quarreling with each other. And because the child was there, a child abuse was likewise filed by the parents against the other party for other forms of abuse. You have there Felina Rosaldes. It states here, not every instance of the laying of hands on a child constitutes the crime of child abuse under Section 10A of Republic Act Number 7610. Only when the laying of hands is shown beyond reasonable doubt to be intended by the accused to debase, degrade, or demean the intrinsic worth and dignity of the child as a human being, should it be punished as child abuse. Otherwise, it is punished under the revised penal code. In other words, RA 7610 is mala in se. Intent to degrade, intent to debase the child is an element of the crime. And in another case, kani crossfire, klaro ha, crossfire, na biktima ang bata. In another case, it was really intended to the child. Intended to the child, ha? However, that was done by the father in defense to his son who is even younger by the other child to whom he attacks. So, in that particular case, the Supreme Court had the opportunity to establish that principle as well, that he has no intention actually to degrade or to debase the child, because he only it was in the spur of the moment that he comes to the rescue of his son who is younger than the other child. So he was not made liable under 7610 as well, but under the RPC. Okay, so that ends 7610. RA 9775, Anti-Child Pornography Act. So who is a child under RA 775? It refers to a person below 18 or over but is unable to fully take care of himself or herself from abuse, neglect, cruelty, exploitation, or discrimination because of a physical or mental disability or condition. Same with RA 7610. Take note of the further definition. A child shall also refer to a person, regardless of age, who is presented, depicted, or portrayed as a child as defined herein. And a computer-generated, digitally or manually crafted images or graphics of a person who is represented or who is made to appear to be a child. That is the definition of a child under RA 9775. So what is child pornography? Again, even if the person is no longer a child, but it could still be child pornography. So what is child pornography? Refers to any representation, whether visual, audio, or written combination thereof, by electronic, mechanical, digital, optical, magnetic, or any other means of child engaged or involved in real or simulated sexual activities. So what you are going to remember here to make one liable of child pornography, because basically we should be aware or conversant of the elements of the crime. So this involves representation, any other kind of representation, visual, audio, written, with the use of electronic, mechanical, digital, optical, or magnetic. And they are performing a real or simulated explicit sexual activities, that is child pornography. What does explicit sexual activity include? Because basically, real sexual activity, we already have knowledge on it. But what includes explicit sexual activity? Take note that this could either be actual or simulated as well. As to form, you have their sexual intercourse or lascivious act, but not limited to involving contact, involving genital to genital, oral to genital, anal to genital, oral to anal, between persons of the same or opposite sex. You also have their bestiality. So for the curiosity of some, so bestiality refers to sexual activity between a person and an animal. You have their masturbation, sadistic or masochistic abuse. So deriving sexual gratification from one's own pain or humiliation. Lascivious exhibition of the genitals, buttocks, breast, public area, and or anus. Use of any object or instrument of lascivious acts. So those are considered to be explicit sexual activity. Please take note of these terms. Grooming refers to the act of preparing a child or someone who the offender believes to be a child for sexual activity or sexual relationship by communicating any form of child pornography. It includes online enticement or enticement through any other means. Take note, they will be doing child pornography, real or simulated. How about luring? Refers to the act of communicating by means of a computer system with a child or someone who the offender believes to be a child for the purpose of facilitating the commission of sexual activity or production of any form of child pornography. While pandering, act of offering, advertising, promoting, representing, or distributing through any means any material or purported material that is intended to cause another to believe that the material or purported material contains any form of child pornography, regardless of the actual content of the material or purported material. So when can one be made liable for child pornography? Or how do we successfully prosecute one for child pornography? There must be representation of a child. That's why in the definition for child, it may include a person who represented himself to be a child. That the child is engaged, whether the child or the supposed child is engaged or involved in real or simulated explicit sexual activity, that the representation of the child may be visual, audio, or written, or combination, that the representation of the child is by electronic, mechanical, digital, optical, magnetic, or any other means. That is to constitute and prosecute successfully a person for child pornography. So what are the prohibited acts under RA 9775? It shall include hiring, employing, using, persuading, or inducing or coercing a child to perform in the creation or production of any form of child pornography. To produce, direct, manufacture, or create any form of child pornography. To publish, offer, transmit, sell, distribute, broadcast, advertise, promote, export, or import any form of child pornography. To possess any form of child pornography with intent to sell, distribute, publish. And then you have there that the possession of 3 or more articles of child pornography shall be prima facie evidence of the intent to sell. Knowingly, willfully, and intentionally provide a venue for the commission of prohibited acts, such as dens, private rooms, cubicles. For film distributors, theaters, and telecommunication companies to distribute any form of child pornography, for the parent, guardian, or person having custody or control of the child to knowingly permit the child to engage, participate, or assist in any form of child pornography, to engage in the luring or grooming of a child, to engage in pandering of any form of child pornography, to willfully access any form of child pornography, to conspire to commit any of the prohibited acts. Take note, to possess any form of child pornography, because the other one earlier, with intent to sell. So it requires at least 3 pornographic materials. So here, possess any form, even one. So in other words, the child pornography here involves creation of these materials. You have there a child or a person that represents a child involved in sexual intercourse or other explicit sexual activity, real or simulated, through the use either mechanically, electronically, digitally, so on and so forth. So that is ACP, child pornography. When shall there be conspiracy to commit child pornography? If the same be committed by 2 or more persons who come to an agreement concerning the commission of the prohibited acts and decide to commit child pornography. When is child pornography deemed committed by a syndicate? Because earlier, conspiracy, here syndicate. If carried out by a group of 3 or more persons conspiring, confederating with one another, it shall be deemed to be committed by a syndicate. May the DOJ execute the request of a foreign state for assistance in the investigation and prosecution of any form of child pornography? The answer is yes, because child pornography is a transnational crime, and it is actually, you have there a specific provision to include child pornography as an extraditable offense. Okay, so that ends child pornography. Oh, napa. Which court has jurisdiction? Family court, okay, family court. If there is no family court in the particular place, RTC designated as a family court. So that ends ACP. Anti-photo and video voyeurism. What is anti-photo and video voyeurism? Look at this picture. Would that be photo or video voyeurism? What is that woman peeping there too? Is it a photo or a video? And how about this? You compare this one. The law defines photo and video or video voyeurism as follows. Means the act of taking photo or video coverage of a person or group of persons performing sexual act or any similar activity, or of capturing an image of the private area of a person or persons without the latter's consent, under circumstances in which such persons or persons have a reasonable expectation of privacy. That is the first act punished under photo or video voyeurism. So going back to the picture earlier, so the act of peeping would not be considered as photo or video voyeurism because the law says taking photo or video. So the one using his cell phone to picture, capture, or record, take a video of someone else who has a reason or a reasonable expectation to have some privacy may constitute photo or video voyeurism. So as shown in the 2 pictures that we have earlier. So the first act here, act of taking a photo or video coverage, or you also have there capturing an image of the private area of a person. Take note that that is not with their consent, obviously without their consent. Another act punish, act of selling, copying, reproducing, broadcasting, sharing, showing, or exhibiting the photo or video coverage or recording of such sexual act or similar activity through VCD, DVD, internet, cellular phones, and similar means or device without the written consent of the person involved, notwithstanding the consent to record or take photo or video of the same act was given by such person. The other act being punished, this implies that there was consent at the time of the taking of the photo or taking of the video. But as to the selling, copying, broadcasting, consent, the written consent of the person involved was not taken. So the person can still be made liable under the Anti-Photo and Video Voyeurism Act. What does private area of a person mean under RA 9995? Private area of a person means the naked or undergarment-clad genitals. I think this is pubic area, buttocks or female breasts or of an individual. So that is the private area of a person. What do we mean by the concept of under circumstances in which a person has a reasonable expectation of privacy under the law? It means that a belief that he or she could disrobe in privacy without being concerned that an image or a private area of the person was being captured, or circumstances in which a reasonable person would believe that a private area of the person would not be visible to the public, regardless of whether the person is in a public or private place. So when we say, of course, private place, we all know that, but you have their public place that we expect some privacy, like the comfort room for that matter. So what are the prohibited acts under RA 9995? To take photo or video coverage of a person or group of persons performing sexual act or any similar activity, or to capture an image of the private area of a person such as the naked or undergarment-clad genitals, pubic area, buttocks, or female breasts without the consent of the person involved and under circumstances which the person or persons have a reasonable expectation of privacy. And the next act is to copy or reproduce, or to cause to be copied, reproduce such photo or video or recording of sexual activity or similar activity with or without consideration. You also have there to sell or distribute such recording or photo, to publish or broadcast such photo or video recording. And then in the prohibition under paragraphs B and C, these two. No, here B, this one B, C, D. The prohibition under B, C, and D shall apply under and is punishable under the law if the selling, publishing, or broadcasting has no written consent, has no written consent of such act of selling, distributing, or publishing, even if at the time of the taking of the photo or recording of the video, they give their consent. So that would still be punishable under RA 9995. You have their exemption from the coverage, meaning to say, immune from being made liable under RA 9995. When would that be? So it shall render unlawful or punishable for any peace officer who is authorized the prohibition under RA 9995 shall not be applicable, shall not render it unlawful or punishable for any peace officer who is authorized by a written order of the court to use the record or any copy thereof as evidence in any civil, criminal investigation or trial of the crime or of photo or video voyeurism, provided that such written order shall only be issued or granted upon written application and examination under oath or affirmation of the applicant and the witnesses. He may produce, and upon showing that there are reasonable ground to believe that photo or video voyeurism has been committed or is about to be committed, and that the evidence to be obtained is essential to the conviction of any person or to the solution or prevention of such crime. So there must be prior authority, a written order of the court to do the recording or taking of a photo, to capture, to obtain evidence against those persons committing a violation under this act. Okay, so let's proceed with Trafficking in Persons Act. So you have their RA 9208 as amended by 10364, also known as the Expanded Anti-Trafficking in Persons Act of 2012. What is trafficking in person? Now, if you notice here, first paragraph is too long. It is too long. And in order for you to give a comprehensive definition of trafficking in person, I made it like this for easy reference. So when you give your definition for trafficking in person, please be guided. Acts means purpose. Your definition must contain the act, the means, and purpose. Meaning to say, trafficking in person is an illegal act and is considered a violation of human rights, and it has three interrelated, interdependent elements for a situation to be considered trafficking in person, such as that there is recruitment, obtaining, hiring, providing, offering, transportation, transfer, maintaining, harboring, or receipt of persons with or without the victim's consent or knowledge within or across national borders, through the use of threat, use of force or other forms of coercion, abduction, fraud, deception, abuse of power or of possession, taking advantage of the vulnerability of the person, or the giving or receiving of payment or benefits to achieve the consent of a person having control over another for the purpose of exploitation or the prostitution of others or other forms of sexual exploitation, forced labor or services, slavery, and voluntary servitude or the removal or sale of organs. So that is your guide. You have to be mindful of the acts, means, and purpose for you to give a comprehensive definition of trafficking in person so that the examiner would give you the maximum possible points for that particular question if asked. The recruitment, transfer, harboring, adoption, or receipt of a child for the purpose of exploitation, or when the adoption is induced by any form of consideration or exploitative purpose, shall also be considered trafficking in person, even if it does not involve any of the means set forth in the preceding paragraph. So let's go back. Means, even if these are absent, the means absent, for as long as you have there the act and the purpose, and the victim is a child, it is considered to be trafficking in person. A child refers to a person below 18 or who is over 18 but is unable to fully take care or protect himself from abuse, neglect, cruelty, or exploitation. Same definition as 7610. So I hope with the acts means purpose, it would be easy for you to remember the comprehensive definition of trafficking in person. In fact, those would also constitute as elements of trafficking in person. So in People versus Casio, it enumerates the acts, the means, and purpose as the main elements of trafficking in person. What acts constitute trafficking in person? So this is just a reiteration, and it is found in the comprehensive definition of trafficking in person. So you have there acts of trafficking as well: to introduce or match for money, profit, or material economic consideration any person under 6955 or to any Filipino woman, to a foreign national for marriage for the purpose of acquiring, buying, offering, selling, trading him or her to engage in prostitution, pornography, sexual exploitation, forced labor, slavery, involuntary servitude, and death bondage. So you have there the mail order bride. So this is the same. Marrying a woman, Filipino woman for that matter, bring him or bring her to another country for purposes or to prostitute her, to exploit her. So that is trafficking in person. You also have there to offer or contract of marriage, real or simulated, for purposes of acquiring, selling, trading them, to engage in prostitution, pornography, sexual exploitation, forced labor, slavery, involuntary servitude, and death bondage. And then you also have there undertake to organize tours and other tourism packages, but offering those persons for prostitution and other sexual exploitation. You also have there to maintain or hire a person engaged in prostitution or pornography. Remember, in the definition of trafficking in person, one of the acts is receiving these recruits, victims of trafficking. So you are also liable for trafficking in person. To adopt or facilitate the adoption of persons. You also have there to recruit, hire, adopt, transport, or abduct persons for the same purpose: to recruit, transport, or adopt a child, to engage in armed activities in the Philippines or abroad. So the purpose there is to exploit these children. So you have there the acts of recruitment, purpose of exploiting them, even if the means are not proven or not attendant, that would still be trafficking in person. Okay, let's proceed to some of the decided cases. This is the case of People versus Lally, GR number 195419, October 12, 2011. Ex of Zamboanga City was recruited and brought to Malaysia on the pretext that she would work as a restaurant entertainer. However, when she arrived, she was forced to work as a prostitute at a bar. Later, she escaped and was able to return to Zamboanga. She filed a criminal case for trafficking in person against her recruiters. Will the case prosper? The case will prosper. One of the acts of trafficking in person is the recruitment or transfer of persons by any means, including those under the pretext of employment, for the purpose of prostitution, pornography, sexual exploitation, forced labor, slavery, and voluntary servitude or death bondage. In this case, X was recruited by means of fraud. Her employment made on the premise that she be employed as a restaurant entertainer and for the purpose of forcing her into prostitution. So that is People versus Lally. How about this scenario? The government through the PAGCOR has allowed the operation of a foreign-operated gambling service in the Philippines. This gambling service is made online and it caters to markets outside the Philippines. Its employees are mostly, if not all, composed of foreigners with special work permits, and many of them are women. So we are actually talking about POGO. X, a foreign national, filed a complaint against the operator of one of the gambling operations, claiming that she is an employee of the said gambling operations and that she was forced to work as a prostitute and entertainer for the customers there. Can the government charge the operator with trafficking in person? The answer is yes. The operator can be charged with trafficking of persons as long as the courts have jurisdiction. One of the acts of trafficking includes recruiting, transporting, transferring, harboring, providing, or receiving a person by any means, including those done under the pretext of domestic or overseas employment or training or apprenticeship for the purpose of prostitution, pornography, sexual exploitation, and other purpose, as long as all of the acts are committed in the Philippines, so Philippine courts have jurisdiction. In another case, X introduced A, B, and C as minor girls to Y, offering him sexual services for a fee of 20,000 per girl. Y paid X an amount. While X was counting the money, Y declared the entrapment operation, and several police officers entered and arrested X. What crime did X commit? Now, the court ruled that he is liable for qualified trafficking in person. The law provides that any person who recruits, transfers, or receives any person by any means for the purpose of prostitution and other exploitation commits trafficking in person. Further, the crime of trafficking in person is qualified when the victim is a child or when the crime is committed in large scale. Trafficking in persons is deemed committed in large scale if committed against 3 or more persons, individually or as a group. So take note, you might be asked, when shall be trafficking in persons considered to be committed in large scale? When shall it be committed by a syndicate? In this case, X transacted with other persons and offered A, B, and C as prostitutes. Because A, B, and C were minors and because the said victims were at least 3, the crime therefore is qualified trafficking in person. Is there attempted trafficking in person? The answer is yes. However, if the victim of trafficking is a child, the following also constitutes attempted trafficking in person: facilitating the travel of a child, executing for a consideration an affidavit of consent or a written consent for adoption, recruiting a woman to bear a child for the purpose of selling the child, simulating a birth for the purpose of selling the child, and soliciting a child and requiring the custody thereof through any means from among hospitals, clinics, and nurseries for the purpose of selling the child. What court has jurisdiction? It shall be filed in the court where the offense was committed or where any of the elements occurred, meaning to say, RTC, regular court. But if the victim or any of the party involved is a child, then that is the time that the same shall be filed with the family court or an RTC designated as a family court. What acts that promote trafficking in person? So just go over them, and they are as well punished under the law. So acts that promote trafficking in person. So those are the acts that promotes trafficking in person. When is trafficking in persons qualified? So earlier we have there when the traffic person is a child, when the same is committed in large scale, and you have there when the adoption is effected through RA 8043 or the Inter-Country Adoption Act, you have there, so aside from committed in large scale, you also have there committed by a syndicate. So when is trafficking deemed committed by a syndicate? Carried out by a group of 3 or more. Large scale, committed against 3 or more, individually or as a group. And then when the offender is a spouse, ascendant, parent, sibling, guardian, who exercises authority over the trafficked person, qualified trafficking. When the offender commits one or more violations of Section 4, acts of trafficking in person over a period of 60 days or more, whether those are continuous or not, when the offender directs or through another manages trafficking victim in carrying out the exploitative purpose. So those are the acts qualifying trafficking in person. We also have the so-called accomplices and accessories in trafficking in person. So, same as the RPC. Aids, abets, cooperates. The accessory, same act as provided in the RPC. So, they are considered to be accessory in trafficking in person. Can a traffic victim be charged for prostitution under Article 202? Meaning to say, he was recruited by means of fraud or deception, and she engaged into prostitution. Can she be charged under 202? So under RA 10158, they are considered to be victims. And since they are considered to be victims, they cannot be made liable for trafficking in person. Okay, because they are regarded as victims. You cannot charge them for prostitution under Article 202 of the Revised Penal Code. Is the character of the victim relevant? Okay, that would be answered in this particular set of facts. Why? The recruiter of X, who was charged with trafficking in person under RA 9208 as amended, pleads in his defense that he cannot be made liable for trafficking in person for the reason that X was already a prostitute and that he did not employ any kinds of fraud or deception. As X was more than willing to work abroad as a prostitute, will X defense prosper? The answer is no. Wise defense. Anong X man Y? Will wise defense prosper? No, wise defense will not prosper. Under the law, the past sexual behavior or the sexual predisposition of a trafficked person shall be considered inadmissible in evidence for the purpose of proving consent of the victim to engage in sexual behavior or to prove the predisposition, sexual or otherwise, of a trafficked person. Okay? Meaning to say consent is immaterial. What would be the effect of the execution of an affidavit of desistance by victims of trafficking in person? Okay, so X, who just returned to the Philippines after escaping from her previous workplace, filed a complaint for trafficking in person against her recruiter. 3 days after filing her complaint, she executed an affidavit for the purpose of desisting in her complaint, citing therein that she is no longer interested in pursuing her recruiters and that it is best to just forgive and forget. If you were the public prosecutor, would you dismiss her complaint? The answer is no, I will not dismiss her complaint. The law expressly states that cases involving trafficking in person should not be dismissed based on the affidavit of desistance executed by the victims or their parents or legal guardians. Public and private prosecutors are directed to oppose and manifest objections to motions for dismissal. Okay, that is actually expressly provided for under the law. Now, you have to remember that when these victims executes affidavit of desistance, actually, they are actually subjected to further victimization, if I say, because of the reason of poverty. They are really vulnerable to all these offers just to execute the affidavit of desistance. So by the mere affidavit of desistance alone, it should not be a ground for the dismissal of the complaint. A was charged with trafficking in person for allegedly recruiting women to work as prostitutes in Australia. A contends that the case against him must be dismissed for the reason that prostitution in Australia, according to him, is legal and a valid profession. Is the contention of A correct? No, the contention of A is not correct. The law mandates that the state shall exercise jurisdiction over any act defined and penalized under this act, even if committed outside the Philippines, and whether or not such act or acts constituting an offense at the place of commission. The crime being a continuing offense having commenced in the Philippines and other elements having been committed in another country if the suspect or accused is a Filipino, is a permanent resident, has committed an act against the citizen. So any of those. In this case, A can still be charged for trafficking in person because the state has jurisdiction over the acts of trafficking even if it was committed outside the Philippines and regardless of whether or not such act is valid at the place of commission. If you notice here, she was recruited. She was recruited in the Philippines. So one of the elements of the crime, which is the act involved here, the recruitment, took place in the Philippines. And further, you have there, if it is committed, if the suspect or accused is a Filipino, permanent resident of the Philippines has committed the act against a citizen of the Philippines, the court or laws applies to him. Now, is probation available for trafficking in person convicts? As a rule, it shall be inapplicable. Okay? Inapplicable. Use of traffic persons is committed by any person who buys or engages the services of traffic person for prostitution. And you have there the penalty for the person who uses a traffic person. So make sure that if you engage the services of a prostitute, she is not a victim of trafficking in person, because if you uses her, you can be made liable and be punished with 6 years to 40 years plus fine. In addition to the imprisonment and fine, if the offender is a foreigner, she shall be immediately deported and permanently barred from entering the country after serving his jail term. And if he is a public official, he shall suffer the perpetual absolute disqualification to hold office. Now I have here chart distinguishing or differentiating trafficking in person from illegal recruitment and from human smuggling. In trafficking in person, it may or may not involve coercion, fraud, deception, abuse, or vulnerability, because the means as provided for by law is very broad. There are lots of means of committing trafficking in person. While in illegal recruitment, it also does not involve coercion, but uses more of deception, promises, and fraud. That's why many have been victimized by illegal recruiters. Human smuggling usually does not involve coercion. In fact, it is the person himself who is actually insistent of being placed inside a van, for example, just to cross borders. In trafficking in person, it is characterized by subsequent exploitation after the illegal entry of one person from one place to another or one country to another. Okay? There would be subsequent exploitation. In illegal recruitment, it is characterized by facilitating entry of one person from one country to another through an unorganized or unlicensed agency. And in human smuggling, it is characterized by facilitating for a fee the illegal entry of a person into a foreign country. Okay? They paid just to cross border. In trafficking in person, there is a need to prove the presence of exploitation or that the recruitment was facilitated for the purpose of exploitation. While in illegal recruitment, the mere recruitment without license is punishable. No need to prove consequential exploitation. In human smuggling, proof of illegal entry by non-compliance with the necessary requirements of travel. So that is the characteristic. And lastly, trafficking person is considered a human rights issue, while illegal recruitment is a migration issue, same with human smuggling. So I hope that the table would help you differentiate one from the other. And I hope to see you again on our next session. So with that, I thank you for your time and good luck on your upcoming bar exams. Thank you.